Good morning, everyone. This is Sean here, Sean Smith with the Smith Law Firm, and I'm sitting here parked about to go to the courthouse. But I wanted to jump on here real quick and talk to you a little bit about power of attorneys. I got a call last week. Someone inquired about executing a power of attorney, using a power of attorney. Basically, they said, Sean, look, my father just passed away. I have this power of attorney where he named me as a power of attorney. I'm ready to get started. And I said to the gentleman, I said, look, that power of attorney is probably as good or not as good or not as valuable as the paper it was printed on. And the person was like miffed. They said, well, why? He executed this a long time ago. Nothing's changed. He named me as his attorney, in fact. And I said, look, power of attorneys are good estate planning tools, but once the person who granted the power passes, they become null and void. There's nothing you can do with it at all. But with that said, they are still important estate planning documents, and what they are is basically just a fancy way of saying I'm authorizing someone else to act on my behalf while I'm alive. And with the general power of attorney, you're handling someone's business affairs, basically. These documents are very powerful documents. With them comes a lot of responsibility, meaning if someone names another person as their attorney, in fact, or what we like to call an agent, that person has a fiduciary relationship. And what that means is that person has to act in the person's best interest. That means you can't use the other person's assets or money for your own benefit. You can't commingle your assets. If the person wants to sell their home and they want you to sell it through the power of attorney, you can't say, oh, well, I got a buddy who wants to buy the home and I could give it to him at a discount. You can't do that because of that fiduciary relationship. Other than that, these are very powerful tools. They're good if one becomes incompetent or incapacitated. For example, if you're incapacitated or you become incompetent and you have no power of attorney in effect, well, guess what? Someone's going to have to file a lawsuit to open up a guardianship conservatorship to act on your behalf, and that could take a long time through the courts. It could be very expensive. It can invite all types of frustrations. Power of attorneys are good documents. They're powerful documents, but they have to be used with utmost discretion and care. Again, this is Sean Smith. This is not legal advice, as always. Look, I don't know you. You don't know me. I'm just providing general information out there. If you do have a specific legal question, however, you may want to give a local attorney a call. I'll see you next time. We're going to talk a little bit more about power of attorneys, healthcare power of attorneys, what they are, why they're good estate planning tools.